Okay. Good morning, everyone. Good morning, my future chartered accountants. Good morning, Om. Good morning, Anmol, Mustafa. Good morning, bachon. So today is the time to discuss about the chapter Incorporation of Company and Matters Incidental thereto. This is revisionary class, and we will complete this chapter in two lectures. One is on today, and another is on Sunday, right? तो गुड मॉर्निंग शुरू हो गई. गुड मॉर्निंग सुनील, रितु, गुड मॉर्निंग अभिषेक. Okay, good morning everyone. So let's start the topic incorporation of company and matters incidental thereto, right? So actually this chapter contains chapter 2 of the Companies Act 2013 regarding the incorporation of companies and matters incidental thereto. This chapter actually will cover the formation of and incorporation of OPC, document required for incorporation of company, incorporation of charitable company, effects of registration, and this part will be covered today. And rest MOA, AOA, alteration in MOA, AOA in the next lecture, that is on Sunday. So let's start with the first point of this chapter is promoter. Actually, in the Act 1956, Companies Act 1956, there was no definition of promoter. Promoter word was used in that act, but not defined. So first time the concept of promoter is defined in the Companies Act 2013 under section 2 clause 69. According to the section, promoter means who has been named as promoter in a prospectus or who is identified as promoter by the company in annual return. किसी की आवाज आ रही, थोड़ा म्यूट कर दीजिए प्लीज. Or who has control over the affairs of the company directly or indirectly, whether as shareholder, director or otherwise. So in simple way, if we go for these 3 points, promoter is the person who has idea about the company, idea about the business, who is supporting the company. Again in point number D, or in accordance with whose advice, direction or instruction the board of directors of companies is accustomed to act. Accustomed मतलब कि वो कहीं ना कहीं इनसे bound है to do according to direction of that person, but shall not include. This is important. But shall not include a person who is acting merely in a professional capacity, such as attorney, technical or functional expert. Same way like a chartered accountant. My client work in his company according to my advice. Whether I am the promoter, the answer is no. So promoter is defined. Once again, we read the definition, and what is the reason of defining the promoter in the act we should understand. So first we should understand who is the promoter. The promoter named as promoter in prospectus, named as promoter in annual return, control over the working of company, whether directly, indirectly, as shareholder, director or any other way, and in whose directions directors are required to work. These 4 persons termed as promoter under section 269, but specifically excluding the person, a professional advisor, the person who is working with the company as a professional advisor, that is not a promoter for the purpose of section 2 clause 69, right? So now come to the point, what is the reason behind defining the promoter in this act? The reason is the person who will be liable as promoter for fraud made through the misstatement. पर्पस क्या था बच्चों कि भाई प्रमोटर के लिए लाइबिलिटी फिक्स है, तो कौन लाइबल होगा भाई? Who will be the liable for fraud due to, through a misstatement? That is promoter. Now, who is the promoter? So, point number A, B, C, D are promoter. They will be liable for fraud through misstatement. So, the definition serves the purpose to make a person liable in capacity of promoter for fraud through misstatement. But uh, definition is not restricted at this 4 points only. Sometimes some judicial decisions have widened the scope of the promoter. According to the case decision in the case Laguna's Nitrate Company versus Laguna Syndicate, to be a promoter, one need not necessarily be associated with the initial formation of the company. One who subsequently helped to arrange floating of its capital will equally be regarded as a promoter. मतलब कि promoter जरूरी नहीं है कि at the incorporation ही person हो जो support कर रहा हो. Even after the incorporation, if person support in the flotation of capital to arrange the capital, expand the business, is also the promoter. Again, it was decided in case of Erlanger versus New Sombrero Phosphate Company. Promoter denotes any individual, association, partnership, or a company that takes all the necessary steps to incorporate. Right? तो कौन हो गया? जो भी काम कर रहा है कंपनी को इनकॉर्पोरेट कराने के लिए, नॉट एज ए प्रोफेशनल कैपेसिटी, विल बी टर्म्ड एज promoter. Right? Now, please read once again the definitions. Just a moment, बच्चों. Clear? Point number A, promoter in prospectus. B, as promoter in annual return. C, control over the affairs of the company. And D, directions. So in this way, you can learn these 4 points. Now, the purpose and the judicial decisions. Please give 1 minute on this slide also. Now, formation of company, section 3. Section 3, subsection 1 provides that a company may be formed for lawful purpose. If the purpose is unlawful, company cannot be incorporated, but by subscribing their name. At least 7 members in case of public company, at least 2 members in case of private company, and 1 member in case of OPC, 1-person company. So what section 3.1 provides? Section 3 subsection 1 provides that a company may be formed for lawful purpose by subscribing their name. ये आवाज बैकग्राउंड में आ रही है, प्लीज देखिए भार्गव जी, इसको म्यूट करिए बच्चों को जरा. Provide that company may be formed for lawful purpose by subscribing their name to memorandum and complying with the requirement of that act. A public company may be formed by 7 or more persons, at least 7. A private company may be formed by 2 or more persons. 1-person company, but as a private company, may be formed by 1 person. Further, subsection 2 provides that company may be limited by shares, limited by guarantee, and unlimited company. Company limited by share means that the liability of members is limited up to the unpaid value of shares that can be called during the lifetime or at the time of winding. In case of company limited by guarantee, the members are liable up to the amount undertaken, which can be called only at the time of binding. And in case of unlimited liability, the liability of members is unlimited, like partners in case of partnership form. Important note, note 1 is a general note. A limited liability company may be company limited by guarantee as well as shares. We have discussed. Second point is specified IFSC companies, public or private company, shall be formed as company limited by shares. It cannot be limited by guarantee. An IFSC company means a company licensed to set up a business in any international financial services center in India, like Gujarat International Finance Taxi. ठीक है, वहां पर कोई जो एरिया बन गए, आईवी सेंटर बने हुए हैं, वहां पर आप बिजनेस सेटअप कर रहे हैं, उसमें अगर कोई कंपनी आप सेटअप करना चाहते हैं, उसके लिए दैट विल बी कॉल्ड आईएफएससी, पब्लिक कंपनी और प्राइवेट कंपनी, बट इट शुड बी लिमिटेड बाय शेयर्स, राइट? नाउ टाइम टू डिस्कस द ओपीसी 1%. Concept of 1% company. This concept was again first time recognized in the Companies Act 2013. In the Companies Act 1956, there was no concept, right? There was no concept regarding 1% company. So in the Companies Act 2013, for the first time, allowed the formation of company by just one person with limited liability, called 1% company. Such a company is described as private company. The 1% company is only private company, it cannot be worked as public company. Section 2, clause 62, the only section which defines the OBC. OPC means a company which has only one person as member. Section 3, subsection 1 should be read along with rule number 3 and 4 of the Companies Incorporation Rules 2014, which provides certain provision regarding the incorporation of OPC. So OPC first time in the 2013 Act. Private company as per section 3 subsection 1. Definition is given in section 2 clause 62, which means a OPC means a company which has only one member, and the provisions are given in sections 3 subsection 1 along with rule number 3 and 4 of the Companies Incorporation 2000. Come to the rules and the concept. First question arises, who can form OPC? Who is the person eligible to form an OPC? The law says only a natural person other than minor, only a natural person other than minor who is an Indian citizen and whether resident in India or otherwise shall be eligible to incorporate OPC. A question arises, in the first line it is mentioned only a natural person other than minor. यहाँ पर अनसाउंड बारे में कोई इंफॉर्मेशन नहीं है. So whether as per these provisions, unsound mind person can form a company, form a OPC? The answer is no. So I think it should be read in such a way that only a natural person capable to enter into a contract, only a natural person capable to enter into a contract who is an Indian citizen and resident in India or otherwise. Now there is no restriction that the person should be resident in India. In originally it was a restriction that person should be resident in India, but now there is no restriction. The person who is not resident in India can also form a OPC. Shall be eligible to incorporate a one-person company, right? So it should be a natural person other than minor, I think it should be capable to enter into the contract, who is Indian citizen and resident in India or not, shall be eligible to incorporate a OPC. Now, who is resident in India? A person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. During the immediately preceding financial year. It means if you have to check whether the person is resident in India or not, as today is the 4th October 2024. So we should have to check the person should be in India for at least 120 days during the period 1st April 2023 to 31st March 2024. Right? So resident in India means a person who has stayed in India for a period of not less than 120 days during the immediately preceding financial year. Right? Now, second point, OPC cannot be incorporated or converted into a charitable company under Section 8. It means OPC cannot work as a charitable company. Second point, note to ka, OPC can't carry out NBFC, non-banking financial investment activities, including investment in securities of anybody. So OPC, the restriction on OPC, it cannot work as a non-profit making organization, or it cannot work as a NBFC, right? Now, concept of nominee. Who is nominee and what is the requirement of nominee? There is an additional clause in MOA, only in case of OPC, in which member has to indicate the name of nominee who shall, in the event of subscriber death or incapacity to contract, become the member of the company. क्या कहा इसमें कि ये additional clause है, and that is only in case of OPC, that in case of subscriber death, that is member's death or incapacity, to become a member of the company. So nominee will become the member of the company in case of subscriber death or his incapacity. Now question arises, who can be the nominee? So because the nominee would be a member, so he should be eligible to be a member. So all the qualifications which are required for member should also be required for nominee. The same way, he should be only a natural person. It cannot be a body corporate. It should be a natural person capable to enter into the contract, who is Indian citizen, and whether resident of India or otherwise, whether resident of India or not, can be a nominee of the in the OPC. But important thing is, when you mention the name of nominee, you should have the consent of the nominee. कि भाई हम ये चाहते हैं कि हमारी जगह पर नॉमिनी कौन आ जाए हमारी कंपनी में, मिस्टर एक्स नॉमिनी, पर बेटा उससे पहले पूछ तो लो कि नॉमिनी है कि नहीं है, क्या वो बनना चाहता है कि नहीं है. तो प्रायर कंसेंट ऑफ द नॉमिनी शुड बी टेकन in form number INC3. So INC3 form is the consent of the nominee to work as a nominee in the OPC. So the name of nominee is submitted into the ROC in form number 32 SPICE along with form number INC3. INC3 is permission, consent of the nominee, and with prescribed fees at the time of incorporation along with MOA and AOA. So
Sir,
nominee consent, yes.
Sir, it says that it includes
Sir,
not
beta,
less than 120 days.
जी.
So, does it include exactly 120 days?
Yes, I told you at least 20 days. पर बेटा प्रॉब्लम अपन लेंगे ये वाला कंसेप्ट होने के बाद. मैं सारी क्वेरी एक साथ लूंगा. अभी क्या है ना, बीच में अपन नहीं ले रहे. अभी ये वाला कंसेप्ट हो जाए ओपीसी का, उसके बाद हम लोग सुपर ओवर स्टार्ट करेंगे, बट उससे पहले सारी क्वेरी रिगार्डिंग ओपीसी आई विल टेक. तो प्लीज वेट फॉर सम टाइम. ठीक है, ठीक है. तो वंस अगेन द कंसेप्ट ऑफ नॉमिनी. नॉमिनी मीन्स the person who will be as hold the position of member in case of death or incapacity of the member, and this should be added in the MOA as additional clause, right? But prior consent should be there. Regarding the qualification of nominee, so because the nominee should be a member, so he should have the qualification which are required for a member. So it should be a natural person capable to enter into a contract. He should be Indian citizen, whether as in India or not, right? Now, what is the purpose of appointment of nominee? The purpose of appointment of nominee is to ensure the perpetual succession of the legal existence of OPC. भाई एक ही मेंबर होगा, वही मर गया तो फिर कौन चलाएगा, राइट? तो इसके लिए नॉमिनेशन क्लॉज पहले से ही डाल दिया जाएगा. See the example, Miss Madhu formed an OPC wherein Mr. Sudan is nominee as his name is specified in MOA along with his consent. Miss Madhu declared insolvent pending to discharge insolvency and she becomes incompetent to contract. Hence, Mr. Sudan becomes the member of such. भाई मेंबर को इंसॉल्वेंट हो गया तो नॉमिनी कौन बन गया? ऑटोमेटिकली मेंबर, राइट? नाउ दिस provision is important, practically important. When nominee becomes member, please listen carefully these provisions. A natural person shall not be a member of more than one OPC at a point of time, and said person shall not be nominee of more than one OPC. Law is specifically providing the one person can be a member in one OPC and at the same time he can also be a nominee in one OPC. यानी सपोज मैं एक कंपनी में मेंबर हो सकता हूं ओपीसी में और एट द सेम टाइम मैं किसी और ओपीसी में नॉमिनी भी हो सकता हूं. बट प्रॉब्लम विल अराइज, सी where a natural person being in OPC in accordance with the rule becomes a member in another such company by virtue of his being a nominee in OPC. मैं A लिमिटेड A OPC में मेंबर हूं एंड B में नॉमिनी हूं. अब B OPC में मेंबर की डेथ की वजह से मैं ऑटोमेटिकली मेंबर बन जाता हूं. Then at this point I am the member in two OPCs. What should be done? So law says such person shall meet the above specified criteria, that is can be member in only one OPC within a period of 180 days. यानी कि अगले 180 दिन में I have to leave one company, one OPC, and another person will be appointed as member in the OPC. क्लियर इतनी बात कि अगर दो कंपनी में बन गए बाई चांस, एक में मेंबर थे दूसरी में नॉमिनी थे, नॉमिनी मेंबर बन गए क्यों? क्योंकि जो ओरिजिनल मेंबर थे उनकी डेथ हो गई. नाउ वी हैव द 180 डेज टू फुलफिल द क्राइटेरिया ऑफ वन member, one person can be a member in one, right? Please read it carefully. Please note 180 days because it may be a practical question, descriptive question in your exam on this time of 180 days. Now, question arises whether nominee can withdraw his consent. Nominee has given the consent in form number INC3. Now afterwards he is not interested to work as a nominee. He should not want to be a nominee in that particular OPC. So whether he can withdraw his consent, the answer is yes. The law says the nominee may withdraw his consent by giving a notice in writing to such sole member and OPC. And please underline and it means he has to give the notice to the member and also to the company. In such case, the member shall nominate another person as nominee within 15 days of receipt, please underline, of receipt of notice of withdrawal, and shall send intimation of such nomination in writing to the company, along with the permission of new nominee in the form number INC3. Nominee अपनी consent withdraw कर सकता है, but he has to give the notice to member and also to OPC. And in this case, the member shall nominate another person as nominee within 15 days of the receipt of notice, and shall inform the company along with the prior permission of person who work as nominee, who will be appointed as nominee in form number INC3. An important thing, this change shall not be taken, shall not be considered as alteration of M. Right? So, एक बात तो हो गई कि सब nominee has right to withdraw his consent, but whether member can replace the nominee? क्या member ने पहले appoint किया, अब क्या बाद में change कर सकता है? The law says yes. The member may change the name of nominee at any time for any reason, including, this is inclusive, including in case of death or incapacity of contract, after obtaining the prior consent of new nominee in form number INC. Right? So member can do so by intimation in writing to the company. This clear. Important note 2. This is not specified. What we are saying from few minutes, that prior consent of nominee, but please read note number 2. This is not specified either in the act or rules whether intimation shall be prior to making charge or can be made afterwards. But if we consider reasonable construction, the intimation shall be prior. ऐसा कहीं लिखा है कि वो जो कंसेंट है प्रायरली पहले लेनी है बाद में लेनी है, बट लॉजिकली रीजनेबल कंस्ट्रक्शन फॉलो करते हुए ये डिसाइड करते हैं कि इट शुड बी अ प्रायर. राइट? नाउ व्हेन नॉमिनी बिकम्स मेंबर, अब नॉमिनी बिकम्स द मेंबर, वी आर टॉकिंग अबाउट दिस पर्सन, दिस नॉमिनी who is the nominee in only one company and he is not member at any other OPC. हम यहाँ जो बात कर रहे हैं वो उस पर्सन की कर रहे हैं जो केवल नॉमिनी था किसी ओपीसी में और कहीं भी वो मेंबर नहीं था. नाउ ही बिकम्स द मेंबर when the sole member ceases to be a member and nominee become new member, then such new member shall nominate within 15 days of becoming member a person that is new nominee. ठीक है, 15, अब आप मेंबर बन गए, आपका टाइम में 15 का 15 में नया आदमी अपॉइंट कर लो. नाउ इन ऑल द 3 केसेस ऑफ चेंज डिस्कस अर्लियर, withdraw of consent by nominee, replacing nominee with another one, and nominee become member, the company has to inform to ROC within 30 days of receipt of notice in form number INC4 along with the prescribed fees along with the prior consent of such new nominees in form number INC. तो 30 days में कंपनी को इन्फॉर्म करना है ROC, 15 दिन में नया नॉमिनी अपॉइंट करना है और कंपनी ओपीसी विल इन्फॉर्म करेगी, किसको करेगी? आरओसी को, सब नया नॉमिनी अपॉइंट. नाउ व्हाट आर द रिलैक्सेशन अवेलेबल टू एन ओपीसी? क्या क्या बेनिफिट मिल रहे हैं ओपीसी को? छोटी कंपनी है, अकेला आदमी है करने वाला. फर्स्ट, नॉट रिक्वायर्ड टू प्रिपेयर ए कैश फ्लो स्टेटमेंट. No requirement of signing of annual return by company secretary. One director may sign the audited financial statement and director report. Holding of AGM as per under section 96 is not required in case of OPC. Provisions under section 100 to 111 are not applicable for OPC. Only 2 board meetings are required in the calendar year. Only board meeting in each half year is required. As per section 137, OPC are allowed to file the financial statement within the 6 months from the close of financial year as against the 30 days of AGM. Because in OPC, AGM is not required, so financial statement can be submitted to ROC within 6 months from the end of the financial year. In other companies, in other classes of companies, other categories of companies, financial statement should be submitted within 30 days of AGM, right? So this was the concept of OPC, but I'm trying to discuss the super over. But before it, I'm taking your queries on OPC.
Sir, a clarification, sir.
Please,
Hello.
Ji, please.
Sir, regarding companies limited by shares, in the liability clause, it was told that the amount not paid, unpaid on calls amount is liable for that particular shareholder. Whether it is enforceable, sir.
You are saying that, I think you are saying that the clause is mentioned that suppose the capital is rupees 10, 1 lakh, and in the share of 10 rupees each,
Yes,
and
sir.
5 rupees is paid. Now
Yes,
your
sir.
query, I think your query is the rupees balance of 5 rupees can be claimed.
At the time, if the company is liquidated in between, that I am
Yeah.
asking, sir.
Listen. In case of company limited by share, unpaid value of share can be claimed, can be demanded by the company during the lifetime or at the time of winding up. Both cases. But in case of company limited by guarantee, the amount undertaken can be claimed only at the time of winding up or dissolution. Right?
That clause is okay, sir. What you're telling, clause I am accepting. Whether it is enforceable and whether that said members will pay that amount, I am asking. That is, I am asking.
I'm not getting what we want to say. Please, please ask once again.
Whether the particular shareholder, you have to pay that 5 rupees called amount, he has due to pay to the company. If the company is liquidated, then if he pays that 5 rupees, that 5 rupees has gone. So
No, no,
whether anybody will pay that 5 rupees, I am asking.
Yes, can claim, can enforceable. Yes.
So they have to, through court of law, they have to do it, sir.
No, I think you are asking, जो समझो, I am just understanding whether the company can claim, na? Whether the
Yes, sir.
company can, yes, company
Whether the
can
company
claim.
can claim and whether the shareholder will be willing to pay during that period.
The
I am asking.
shareholder has to pay. If shareholder doesn't pay, that company can claim through the court.
Okay, sir. Okay, thank you.
Okay, thank you. And now,
But any such situation happened, sir, during the past?
Pardon?
During the past, any such issue happened, sir? Any case like there, I must.
No, I mean that is not in my knowledge. If possible.
Okay, sir. Okay, thank you, sir. Thank you.
Okay. Abhijit Chaudhary is asking about the, sir, please tell 180 days criteria in short once again. Listen, suppose I am the member in OPC and also a nominee in BOPC, right? Due to the death of the member of BOPC, I become the member in BOPC also. So at this point of time, I am the member in AOPC and I am the member in BOPC. So I have the time of 180 days from the date I am become the member in BOPC. In 180 days, I have to decide in which company, in which OPC I have to be continue as a member, and in other I have to leave, and another person will be appointed as nominee, and he will be the member in the company. या कि मान लीजिए कि जैसे मैंने मैं ए कंपनी में मैं मेंबर हूं एओपीसी में, बी कंपनी में मैं नॉमिनी हूं, बी कंपनी के मेंबर की डेथ हो जाती है, इस वजह से मैं बी ओपीसी मेंबर बन जाता हूं. अब सबसे पहले मुझे 180 दिन के अंदर ये चीजें क्लियर करनी है कि मुझे किस ओपीसी मेंबर रहना है. तो मुझे क्या करना है कि मुझे बीओपीसी में पहले 15 दिन के अंदर, विद इन 15 डेज, आई हैव टू अपॉइंट ए नॉमिनी in BOPC, right? And in that case, I have to leave one OPC and the nominee of that OPC become the member. So within 180 days, I have to follow the rule. One person can be member in one OPC, right?
Sir, one more clarification, sir. Regarding a one-person company, who will be the directors, sir? Directors.
Director may be the member, maybe the other person, because the maximum limit of directors in case of OPC is 15 members, 15 persons. 15 there may be the maximum 15 directors in case of OPC, right?
So other than this one person, remaining 14 persons may be outsiders.
Yes, maybe.
Okay, sir.
Okay. Sir, OPC can be a banking company. The answer is no. Sir, Rishabh is asking, sir, if the nominee of OPC is married to a person and she leaves India, then still such nominee continues to be the nominee of such OPC. Okay, please listen the provisions of OPC regarding the member and the nominee are connected with the person only, not about his spouse or his or her spouse. Sir, if one person company member are dead, the nominee become a owner. Nominee is not a owner, he is the member because it is a separate legal entity. Please mute कर दीजिए जरा. Swati is asking, sir, in case of company limited by guarantee, the guarantee is provided in terms of money or in terms of percentage. I think it should be in terms of amount. Okay, so let's start the super over one and please send the answer in one shot only. ठीक है, जो लोग पढ़े हुए हैं पहले से फाउंडेशन में पढ़े थे मुझसे तो उन्हें पता है कि उन्हें आंसर कैसे भेजने हैं. ठीक है, लेट्स स्टार्ट. It is just the revision of OPC, right? What is the primary characteristics of a OPC? It requires minimum 2 directors. It can have only one member. It is only for non-profit entities. It must have a minimum paid up capital of 10 lakhs. Second question, who can be the nominee for an OPC according to the Companies Act 2013? Only a relative of member, any individual who is competent to contract, a corporate entity, only a professional. Which of the following is not a mandatory requirement for an OPC? Signing of annual return by company secretary, holding of AGM, 4 board meetings in each calendar year, all the above. Question is, which is not mandatory? Which is not mandatory? Whether A is mandatory, whether B is mandatory, whether C is mandatory. If nothing is mandatory in ABC, then D is the answer. So please read carefully. In case of an OPC who has the authority to make decisions on behalf of the company. In case of an OPC who has the authority to make decisions on behalf of the company, the member, nominee, both member and nominee, board of directors. Which of the following is a feature of an OPC under Companies Act 2013? Which is a feature? Unlimited liability, no requirement for annual returns, limited liability of the member, mandatory appointment of an auditor. Which is the feature? And last is sixth ball of the over, where the sole member ceases to be a member and the nominee become new member, then new member shall nominate within space days of becoming a member a person that is new nominee. 7, 10, 15, 30. So let's start the answers. What is the primary characteristics of a one-person company? It has only one member. Who can be the nominee? An individual who is competent to contract. Who can be the nominee? Which of the following is not mandatory requirement for an OPC? Not. So signing of annual return is not required. Holding of AGM not required. 4 board meetings at least not required. So answer is D. बच्चों प्लीज पहले तो आप लोग म्यूट कर लो, बड़ा डिस्टर्ब होता है, बाकी बच्चों की गलियां पड़ेंगी, क्या फायदा आपको. Fourth, in case of an OPC who has the authority to make decision on behalf of the company, who will take the decision? The answer is member. Directors are working on the instructions of the member. वो केवल वर्किंग करने के लिए ऑथराइज है, बट अल्टीमेट डिसीजन अथॉरिटी इज अ मेंबर. Which of the following is a feature of OPC under Companies Act? Limited liability of member. "15 days." Sorry, shall not within 15 days. Yes. मैंने ना सभी को बोला, अब कितने लोग मेरी बात ध्यान सुनते हैं ये मुझे अभी मालूम पड़ रहा है चैट बॉक्स में। मैंने सभी को बोला, आई टोल्ड ईच एंड एवरी वन कि प्लीज सेंड द आंसर इन वन शॉट, and that is only Mr. Om Krishnan, the first person who has listened my words and sent all the answer in one shot. And congratulations, your all answers are correct, Mr. Om Krishnan. Mr. Shoaib, congratulations, your all answers are correct. Pratima, congratulations. Swati, congratulations, and one more, Pooja. These are the first 5 person who has given all the correct answers. I think Ritu, Kashish, Anmol, Khushi, all have given correct answers. ठीक है, तो ये अब आई थिंक ओपीसी कंसेप्ट इज क्लियर टू ऑल ऑफ यू। अब मुझे लगता है कि ओपीसी अब दिमाग में सेट रहेगा, अब कोई कंफ्यूजन नहीं होगा रिगार्डिंग ओपीसी। लिसन,
सर
एक्चुअली यस प्लीज।
सर इसमें जो क्वेश्चन नंबर 4 है इसके अंदर सर यस
जस्ट वेट, यस
सर कंपनी की डेफिनेशन होती है कि कंपनी अलग, मेंबर अलग, एंड जो मतलब डिसीजन लेते हैं वो मैनेजमेंट लेता है, तो उस अकॉर्डिंग टू सर इसमें
लिसन 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 लिसन
ओके ओके सर समझ गई। बोर्ड ऑफ
ना
डायरेक्टर
every board are authorized, right? Or who authorize members in their general meeting, right? So ultimate decision making is in the hands of members. Clear concept? भाई बोर्ड मेंबर्स बोर्ड मीटिंग में वो पहले से ऑथराइज किए जाते हैं रिकॉर्ड अकॉर्डिंग टू आर्टिकल्स की क्या काम कर सकते हैं रेजोल्यूशंस के जरिए, लेकिन फाइनल डिसीजन जो लिया जाता है वो कौन डिसाइड करता है? वो मेंबर डिसाइड करते हैं। मेंबर्स की पावर होती है कि वो इवन डायरेक्टर को चेंज भी कर सकते हैं, राइट? तो अल्टीमेट डिसीजन मेकिंग पावर इज इन द हैंड्स ऑफ मेंबर्स। क्लियर?
ओके सर।
Okay. So I'm talking about that this chapter is important not only for exam but your practical life also. Because जब client आपके पास पहली बार आएगा ना, when the client will come first time before you, so he will ask about the formation of company. And believe me, if you satisfied him his queries about the formation, he will be always be yours. मर जाएगा वो, आपको छोड़ के नहीं जाएगा। तो इसलिए इस पे बहुत फोकस करना है। फर्स्ट इंप्रेशन इज द लास्ट इंप्रेशन, एंड बिफोर योर क्लाइंट दिस चैप्टर इज मेकिंग योर फर्स्ट इंप्रेशन। तो प्लीज रीड इट केयरफुली, नॉट ओनली फॉर एग्जामिनेशन पर्पस बट ऑल्सो फॉर योर प्रैक्टिकल लाइफ पर्पस। ठीक है? एंड आई एम ऑलवेज से विद माई स्टूडेंट्स दैट योर नेक्स्ट 5 years विल डिसाइड योर रेस्ट ऑफ 50 years। अगर अभी 5 साल पसीना बहा दिया तो अगले 50 साल पसीना नहीं, ना आंसू बहाने हैं ना पसीना बहाना। ठीक है ना? तो लेट्स स्टार्ट विद अनदर टॉपिक दैट इज रिडक्शन इन मिनिमम मेंबर्स, सेक्शन 3A। एक्चुअली दिस section was introduced in the Companies Amendment Act 2015. According to it, if members are according to it, members are severally liable, personally liable for the payments of the debts of the company if at any time member reduce below the minimum number of member required. That is 7 in case of public company, 2 in case of private company, and such company carries on the business for more than 6 months with reduced number of members, and every such person who carries on the business after those 6 months is aware of the fact, उसको पता है कि नंबर ऑफ मेंबर कम हो गए फिर भी वो काम कर रहा है, कंटिन्यू चल रहा है। In such case, the lifting of corporate veil, the separate legal entity is disregarded. and such members are liable for the payment of whole debts of the company during that time after 6 months. Right? Please read it once again. Members are severally liable for the payment of the debts of the company if at any time members reduce below 7 and 2 in case of public and private company respectively, and such company carries on the business for more than 6 months with reduced number of members, and every such person who carries on the business after those 6 months is aware of the fact, यानी कि वो he have the knowledge, that members are below the minimum number of members. If he is innocent, he doesn't have idea, so law says he will not be responsible, but burden of proof is on him. He has to prove that he was unaware of the fact the company is working below the minimum number of members. Clear? And these persons or persons will be liable for the liability incurred after 6 months of this date. See the example. Amar Akbar Anthony, along with 5 of their friends, were member of Harmony Limited. That is total 8 members in the public company Harmony Limited. Amar and Akbar died on 18th August 2022. 2022, resultantly, members count reduced to 6 and everyone aware about it. Harmony Limited continues its operation without increasing the member. In March 2023, that is after 6 months, company took loan for business operation and defaulted in the payment. Now the lender of such loan can sue company or Anthony or any of the rest of 5 friends, because in this case members shall be personally liable for the said loan in the given case. Statement: members who knowingly operating the company for more than 6 months with less than the minimum number of members specified in section 3 subsection 1 are severally liable for the payments of the all debts contracted by company during the period since, ये क्वेश्चन है बच्चों, since the number of members were first reduced. The answer is false. Refer to section 3A of the Act. Such members are liable severally for the payment of the whole debts of the company contracted during that time after elapse of 6 months. Clear? Please read once again. I am just giving 1 minute on for this slide. Please read it once again. Concept clear हो जाएगा. Please एक बार दोबारा पढ़िए. Right? Now the incorporation of companies, section 7. So this picture has been taken from your study module and that clearly defined the steps one by one. First, determine the nature of company, whether it is private or public. Then second, reservation of name by filing the application. Then step is drafting the MOA and submission of statutory declaration of compliances, consent of the person who are nominated as directors, submission of MOA and AOA to ROC, payment of the prescribed fees. Then ROC will give the certificate of incorporation, and then file the declaration about the address of the registered office. So please 1 2 3 4 5 6 7 8 9 एक बार read करिए बच्चों इनको. And now we will discuss each every step one by one. किसी पर्सन ने हाथ उठाया अभी, बेटा इसका थोड़ा सा रुक जाइए, आप नोट कर लीजिए अपनी क्वेरी. आफ्टर दिस कंसेप्ट आई विल टेक योर क्वेरीज. ठीक है, तो प्लीज वेट. Now first step, filing of document and information with registrar, that is ROC, subsection 1 of section 7. Subsection 1 provides an application for registration of company shall be filed with registrar within whose duration the registered office of the company is proposed to be situated in SPICE plus form, that is a simplified performa for incorporating company electronically, plus INC 32 is actual form, along with the fees as prescribed, accompanied by the following document and information. Actually this subsection is important also because जब client आपके पास आता है ना, सर क्या क्या कागज चाहिए, सर what documents are required, what papers are required to form a company for me, इसलिए ये बड़ा इंपॉर्टेंट है. और उस समय आपने कहा अच्छा मैं देख के बताता हूँ यार, प्लीज लेट मी चेक, वो कहेगा ऐसे पता ही नहीं कुछ, किसी और से कराते हैं काम. तो प्लीज ये नॉलेज, यू शुड हैव द नॉलेज ऑफ दीज डॉक्यूमेंट्स, राइट. तो accompanied by the following documents and information. First is duly signed MOA and AOA, declaration of compliances by professional and directors, manager or the secretary of the company, declaration by subscriber to the MOA and person named as the first directors, address for correspondence till the opening of registered office, particulars of the person named as the first directors and particulars of the subscriber to the MOA, जो लोग बनने जा रहे हैं मेंबर, जो लोग डायरेक्टर बनने जा रहे हैं उनकी इंफॉर्मेशन. तो व्हाट इज द डॉक्यूमेंट्स? MOA, AOA, compliance, declaration of compliances, declaration by subscribers, address for correspondence, particulars of directors and the subscriber to the members, right? First is duly signed MOA and AOA. Please listen. EMOA in form number INC 33 and article EAOA in form number INC 34 shall be duly signed by all the subscriber to the memorandum in the manner prescribed. Prescribed means prescribed as per the rules. ठीक है, तो INC 33 बनना है, INC 34 बनना है आपको. And each subscriber shall add what he will add: name, full name, address, description, occupation, if any, in the presence of at least one witness who shall attach his signature, shall sign, who shall attach the signature of subscriber, shall sign and add his name, address, description and the occupation of any. यानी कि हर सब्सक्राइबर का नाम जाएगा, उसका एड्रेस जाएगा, डिस्क्रिप्शन जाएंगे, तो साइन होंगे और उन साइन को विटनेस करेगा कोई एक विटनेस. ठीक है, और जो विटनेस करेगा उसका भी नेम, एड्रेस, डिटेल जाएंगी उसके साथ. इफ where a subscriber is illiterate, he cannot sign. He shall affix his thumb impression or mark which shall be described as such by the person writing for him, who shall place the name of the subscriber against or below the mark and authenticate it by his own signature, and he shall also write against the name of subscriber the number of share taken by him. Wait. Please read once again line 1. Where a subscriber is illiterate, ठीक है, he shall affix his thumb impression, ये बात समझ में आती है कि अगर पढ़ा लिखा नहीं है तो अंगूठा लगाएगा, और mark which shall be described as such. Now what is the concept, what is the reason about the word mark? मुझे भी लगा यार ये क्यों लिखा है, कहीं क्लैरिफिकेशन नहीं है। तो मुझे लगा कि आई थिंक दिस शुड बी बिकॉज ऑफ देयर प्रॉब्लम फॉर थंब इंप्रेशन। कोई आदमी तो दोनों अंगूठे ही नहीं है, एक्सीडेंट चले गए, कोई रीजन हो सकता है। तो आई थिंक इन दैट फॉर दिस पर्पस इट इज फॉर मार्क, कोई और मार्क दैट शुड आल्सो बी विटनेस और शुड बी दैट शुड आल्सो बी अटेस्टेड बाय विटनेस। यानी कि अगर पढ़ा लिखा नहीं है तो अंगूठा लगाना है, अंगूठा लगाने कोई प्रॉब्लम है, कोई दिक्कत है, तो कोई और मार्क, बट उसको विटनेस कौन करेगा, उसको अटैच करेगा एक विटनेस, जिसमें विटनेस का नाम एड्रेस सब डिटेल लिखी हो। सब मेरे सामने लगाया, ये वही आदमी है और कोई आदमी नहीं है। नोट, द टाइप written or printed particulars of subscriber and witness shall be allowed. It may be details of subscriber may be typewritten or printed or handwritten, allowed as it is written so long as appends signature or thumb impression. अगर उनके सिग्नेचर है उनके नीचे और उनके नीचे उनका थंब इंप्रेशन है तो ये माना जाएगा ये उन्होंने ही मेंशन किया है। इट मींस it need not to write in by hand the details of subscriber or witness. They can be printed, but it should be appended by signature or thumb impression. Right? Please read once again this slide, the first slide for purpose of incorporation. C point. Whether the subscriber is a body corporate. It means the person who is going to be a member of the new company is a body corporate, not a particular, not a natural person. The MOA and AOA shall be signed by the director, officer, or employee of the body corporate, which is duly authorized for this purpose by the directors through a resolution. If subscriber is body corporate, then body corporate cannot sign, वो खुद से sign करेगी नहीं। So that MOA and AOA shall be signed by the duly authorized person, by director, and that may be director, officer, or an employee of that body corporate, and that should be authorized by the resolution passed in the board meeting, right? But in case subscriber is a LLP, then shall be signed by the partner, not an employee, not officer. That should be signed by the partner of LLP, and that is duly authorized by resolution, approved by all the partners, not majority, not two. It should be by all the partners. Please underline. If there are 10 partners in LLP, 9 are agree, 1 is not agree. That is not approval for this purpose. 10 पार्टनर है, 9 ने अप्रूवल कर दिया, एक ने नहीं करा, तो अप्रूवल नहीं माना जाएगा, बिकॉज इट शुड बी अप्रूव्ड बाय ऑल द पार्टनर्स. Important note, in either case C or D, body corporate LLP, the person so authorized shall not at the same time be subscriber to the MOA and AOA. What does it mean? कोई बताएगा इसको मुझे चैट बॉक्स में लिख के? What does the mean of a note? Anyone?
Sir, can I tell, sir?
Yeah, please.
Sir, in a body corporate, it has to be represented by, because it is a legal entity, it has to be represented by a person. It may be a director, officer, or employee of that body corporate.
Yes.
And in case of LLP, one partner has to sign on behalf of the LLP. Here in this case, In the MOA, the initial subscribers, all the initial subscribers will be listed in the MOA. So this particular authorized persons shall not apply for the company in their individual capacity. That is
Yes,
the
yes.
clause.
So he's right कि the person who is representing the body corporate or the LLP cannot be a individual subscriber, cannot subscriber for his own, right? So I think it is concept is clear to all of you. So आगे बढ़ते हैं. Key point. Where subscriber to a MOA is foreign national residing outside India, foreign national, foreign citizen, his signatures and address of MOA and AOA and proof of identity shall be notarized. Address on MOA, AOA and proof of identity shall be notarized by notary public with a certificate. So in this case, the person is foreign national, his details are attested by notarized notary public, not by a normal person. Further, if such person residing in a country outside the Commonwealth or which is not a party to the Hague Apostille Convention 1961, the certificate of notary public shall be authenticated by diplomatic or consular officer again. अगर कॉमनवेल्थ के बाहर है या जो कॉमनवेल्थ के बाहर है या वो कंट्री है विच इज नॉट ए पार्टी टू द हेग अपोस्टाइल कन्वेंशन 1961 एंड दैट शुड बी approved by, attested by या authenticated by diplomatic or consular officer. Fifth point, another important point, where subscriber to MOA is foreign national, where subscriber to MOA is foreign national residing outside India, visited in India and intended to incorporate a company. In such case, incorporation shall be allowed only if he or she is having a valid business visa. And in case of person is of Indian origin or overseas citizen of India, requirement of business visa shall not be applicable. I am just reading once again. This is the point number F. Where subscriber to MOA is foreign national, residing outside India, visited in India and interested to incorporate a company in India, and he or she will be allowed only if he or she is having a valid business visa. But if the person is of Indian origin or overseas citizen of India, NRI, requirement of business visa shall not be clear. Now, second point, a second requirement document required, a declaration of compliance by professional and director, manager or secretary of the company. So please listen carefully. Once again, I'm saying declaration that all the requirements of the act and rules made thereunder in respect of registration and matter precedent or incidental thereto have been complied. डिक्लेरेशन देना है कि सारी रिक्वायरमेंट पूरी हो चुकी हैं एंड दैट शुड बी filled in form number INC 8. But who will give this declaration? Who will be responsible for this declaration? The law says an advocate, CA, CS, company in practice, advocate, CA, cost accountant, CMA, or CS in practice who is engaged in the formation of company and अंडरलाइन कीजिए and यानी one professional person and इन सब में से एक साइन करेगा एडवोकेट सीए कॉस्ट अकाउंटेंट कंपनी सेक्रेटरी इन प्रैक्टिस एंड plus one person who is the person may be director, may be manager or may be secretary of the company. So at least two person, एक बाहर का आदमी और एक घर का आदमी, one from outside, one from inside, should make the declaration that all the requirements of the act and rules made thereunder have been in respect of registration have been complied with. So you can think, can you think what was the requirement of this provision? कि भैया हम चेक नहीं करेंगे, आप चेक करके भेजो, कल की कुछ गलती हुई ना तो आपकी गर्दन पकड़ी जाएगी. The government is saying please check internally and externally by professional. If there is any fault, these two persons will be responsible. The idea behind this point. So declaration should be submitted to ROC that all the requirement of act and rules regarding the registration have been complied with, and that should be made by the professional person, maybe an advocate, maybe company secretary, maybe a cost accountant, maybe chartered accountant practice, and also one from internal management, maybe a director, maybe manager or the secretary of the company. ठीक है? Now the declaration by subscriber to MOA and person named as first directors, यानी कि जो सब्सक्राइबर्स हैं और जो डायरेक्टर बनने जा रहे हैं उन लोगों को भी डिक्लेरेशन देना है इन फॉर्म नंबर INC 9. A declaration in form number INC 9 from each of the subscriber to MOA and from person named as the first directors, if any, in the articles of association, stating that क्या बताना है, what to be declared, that all the documents filed with registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief, and he is not convicted of any offense in connection with the promotion, formation or management of the company, or he has not been guilty of any fraud, misfeasance or of any breach of duty to any company under this act or any previous company law during the last 5 years. पिछले 5 सालों में आप कोई आपका कोई कन्विक्शन इससे कन्विक्टेड नहीं हुए हो, आप कोई आपने ऑफेंस नहीं किया हो किस रिगार्डिंग कंपनी के प्रमोशन और फॉर्मेशन, और जो इंफॉर्मेशन आप दे रहे हो दैट ऑल आर करेक्ट एंड कंप्लीट एंड ट्रू एज पर योर नॉलेज एंड बिलीफ, राइट. Declaration by professional and the internal management that all the requirement of rules and regulation act are complied with regarding the registration. One declaration by subscriber and the first director that that all the documents are submitted are true, correct and complete to their best to the best of their knowledge and belief, and they are not convicted in the previous 5 years regarding the formation, promotion of the management of the company. Yeah, he is not convicted for last 5 years for fraud or misfeasance of breach of duty under the Companies Act. This Companies Act 2013 or Companies Act 1956, right? I think because there are more than 5 years for the Companies Act 2013, I think or any previous company law बहुत ज्यादा इसकी रेलेवेंस नहीं है. ठीक है. So one other information to be required to be submitted, that is the address for correspondence till registered office is established. जब तक रजिस्टर्ड ऑफिस नहीं बन रहा भैया चिट्ठी पत्री कहां पर करें, कहां भेजें, वेयर टू सेंड द डॉक्यूमेंट्स, तो टेम्परेरी करस्पॉन्डिंग एड्रेस. Particulars of person named as the first director. क्या क्या इंफॉर्मेशन चाहिए डायरेक्टर के बारे में? नेम, सरनेम और फैमिली नेम सेम मीनिंग. सरनेम फैमिली नेम मीन सेम मीनिंग. तो इट मीन्स फुल नेम इज रिक्वायर्ड. डायरेक्टर आइडेंटिफिकेशन नंबर DIN, residential address, nationality, and such other particulars including proof of identity and proof of identity, PAN card, Aadhaar card, and his interest in other firms or body corporate along with his consent, along with the fees as prescribed. It means you have to give the information about the first director, his name, his DIN, his address, his nationality, identity proof, Aadhaar card, PAN card, his interest in other firm, whether he is interested in other firm as a partner, as a director, and also his consent to work as the director for the company with the prescribed. Please read it once again. This is again बहुत छोटी स्लाइड है बट इम्पोर्टेंट है. आपको क्लाइंट को बताना पड़ेगा बच्चों क्या क्या चीज चाहिए तेरे लिए. सर्टिफिकेट ऑफ इनकॉर्पोरेशन, सब कागज सबमिट कर दिए. ऑल द डॉक्यूमेंट्स हैज बीन सबमिटेड टू ROC. Now the ball is in the court of ROC. ROC has to make the registration. So registrar, that is ROC, on the basis of documents and information filed, shall register all the documents and information in the register and issue a certificate of incorporation in form number INC 11. And certificate of incorporation will include a SIN, corporate identity number. The number SIN is the 21 alphanumeric digits base unique identification number. And company shall maintain and preserve all the copies of all the documents and information as originally filed at registered office till its dissolution under this act. यानी कि जो जो डॉक्यूमेंट सबमिट किए आपने उसकी एक कॉपी आपके रजिस्टर्ड ऑफिस में होनी चाहिए जब तक कंपनी जिंदा है. till the dissolution of the company under this act. Please read it once again. Now, furnishing false or incorrect information. अगर गलत भी information दे दी, झूठ बोल दिया, if any person furnishes any false or incorrect particulars of any information or suppresses any material information, गलत बोल दिया, सही को छिपा दिया, and of which he is aware, उसे पता था जानबूझ के, knowingly making the false or correct particulars and suppress any material information in any of the document filed with ROC in relation to the registration of company, he shall be liable for the action for fraud under section 447. 447 में जाके उस पे पनिशमेंट लगती है. ठीक है, बहुत सिंपल सी बात है. बट कंपनी इज ऑलरेडी इनकॉर्पोरेट बाय फर्निशिंग फॉल्स और इनकरेक्ट इंफॉर्मेशन. कंपनी इनकॉर्पोरेट हो गई, बाद में मालूम पड़ा कि इंफॉर्मेशन गलत थी, झूठ बोला था इसने. इस आदमी झूठ बोला था, कंपनी इनकॉर्पोरेट करा ली. अब कौन फंसेगा? Who will be the liable for these acts? Where at any time after the incorporation of company, it is proved that the company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, then promoters, first directors, and the person making declaration, including professional, shall each be liable for fraud under section 447. कंपनी बन गई, बाद में मालूम पड़ा झूठ था उसके अंदर, जानबूझ के बातें छिपाई गई थी, जानबूझ के झूठ बोला गया, तो हु विल बी लायबल? प्रमोटर्स, फर्स्ट डायरेक्टर्स, and person making a declaration that all the information are correct as required as per the act and rules are compliant, right? Now power of NCLT. अब NCLT, अब दादाजी आ गए, दादाजी की पावर क्या है? Where a company has been got incorporated, as discussed in previous slide, false information, incorrect information, दादाजी क्या कर सकते हैं? The tribunal, NCLT, on being satisfied that the situation so warrant, in response to an application made to it, may pass order as it may deem fit, including regulation of management of the company, including changes in MOA and AOA in public interest or in the interest of companies and members and creditors, or direct the liability of the members be unlimited. Bhugto bhai tum. May remove the name of the company from the register of companies, or may order for the winding up. यानी कि अगर लगता है बहुत थोड़ा बहुत काम है तो मैनेजमेंट रेगुलेशन रेगुलेट कर सकती है, इंक्लूडिंग मेकिंग द लायबिलिटी ऑफ मेंबर्स अनलिमिटेड. अभी स्टार्ट हुई है कंपनी, just started, no much work has been done, no much transaction has been done in the company, then the NCLT may order for the removal of the company. But if company has worked for a long time, of number of transactions has been done, so then it may pass the order of winding up. Winding up and dissolution, all the assets will be disposed of. But before making such order, भाई एक मौका तो देना पड़ेगा अपनी बात कहने के लिए. The company shall be given the reasonable opportunity of being heard, and the tribunal shall take into consideration the transaction entered into by company, including the obligation, if any, contractor or payment of any liability. जब डिसीजन लेगा NCLT, he should consider the transaction that has already done by the company, because they should not be harmful for anyone else other than the company. If company has contracted with some other persons, so the NCLT should also consider the benefit loss of that other person. Please read it once again. The power of NCLT. The question may arise in the question may be asked in your exam about the power of NCLT in case the company has been incorporated by false information. So please read it once again. Yeah. Now time for super over 2. I think this super over is connected with the incorporation of company. To be ready, a query here in chat box, and after this super over 2 we will have a break of 5 minutes. Sir, in case clients of Big Four are willing to form company, then such declaration as required and to signed by the professional shall be signed by the partner of such Big Four. Yes, definitely yes. चलो. Yes, please.
सर यहाँ पे फॉरेन नेशनल मतलब फॉरेन सिटीजन
जी जी. ओके लेट्स स्टार्ट सुपर ओवर 2 ठीक है एक बार रिवीजन हो जाएगा इससे आपका members of ABC Limited reduced below minimum on 23rd April 2024 members who knowingly operating the company for more than 6 months with less than the minimum number of members specified in section 3(1) are severely liable for the payment of all the debts contracted by the company on or after. I think this should be not ठीक है right है company debts contracted by the company on or after 23rd April 2024 23rd May 2024 23rd October 2024 23rd April 2025 which document must be filed with registrar of companies to incorporate a company memorandum of association certificate of incorporation annual return notice of extraordinary general meeting next what does the certificate of incorporation signify the approval of the company's business plan commencement of business activities company's existence as legal entity the appointment of directors fourth question which form is required to be filed for submitting declaration of compliance by professional and director manager or secretary of the company inc 7 11 34 or 8 fifth question if it is proved that company has been got incorporated by furnishing any false or incorrect information nclt may order for direct that liability of the member shall be unlimited direct removal of the name of the company from the register of companies winding up of the company any of the above last question which document are required to be accompanied for incorporation of company duly signed MOA and AOA declaration of compliance by professional and director manager or secretary of the company Declaration by subscriber to MOA and person named as the first directors, all the above. So let's start the answers. It should be after 6 months. 23rd October. MOA. It presents existence of legal entity. Which form is required? That is INC 8. If it is proved that company has got incorporated, order any of the above. And all the documents are required. Okay. At this place, we are taking a break of 5 minutes. Bhargav ji, can you hear me, please? भार्गव जी, आप सुन पा रहे हैं मुझे? अच्छा, ठीक है, मुझे कोई इशू। आप बच्चों के जो आंसर्स आए एक बार मैं ले लेता हूं। किसने भेजे हैं? फर्स्ट वन इज प्रतिमा, कॉन्ग्रेचुलेशन बेटा, गुड। शोएब, कॉन्ग्रेचुलेशन। अभिषेक, कॉन्ग्रेचुलेशन। किरण, कॉन्ग्रेचुलेशन। खुशी, ऋषभ, बी साई किरण, अनमोल, Abhijit. Okay, so these person has given all the correct answers. ठीक है? So at this place we are taking a break of 5 minutes. I think technical department में कोई है नहीं शायद अभी, और 5 मिनट बाद रिज्वाइन करते हैं बच्चे। ठीक है? भार्गव जी, आर यू देयर प्लीज? ओके, प्लीज बच्चों 5 मिनट बाद मिलते हैं आपसे। ठीक है?
एक्सक्यूज मी सर।
जी बताएं बेटा।
सर मुझे ये पूछना था कि आप लॉ को कंटिन्यू करोगे या फिर कोई अदर फैकल्टी करेगी?
बेटा एज पर द इंफॉर्मेशन फ्रॉम बोर्ड ऑफ स्टडीज मेरे पास अभी एक लेक्चर आज का है, एक लेक्चर संडे का है। उसके बाद मेरा लेक्चर जीसीए का है, जनरल क्लॉज एक्ट का है और एलएलपी का है। ठीक है बच्चे।
ओके सर।
ओके बेटा, बस 5 मिनट बाद दोबारा रिज्वाइन करते हैं। ठीक है बेटा। Okay, बच्चों, welcome again. Let's start the today's last topic, companies with charitable objects, section 8. प्लीज म्यूट कर लीजिए सब लोग. मेरी हम्बल रिक्वेस्ट है सभी बच्चों से, सारे हमारे फ्यूचर चार्टर्ड अकाउंटेंट से, फ्यूचर मेंबर्स ऑफ द आईसीआई, प्लीज म्यूट कर लीजिए. Now start with the concept, who can issue and get the license under section 8 subsection 1. Now central government, and this power of central government is given to ROC in this point, may grant such a license on the conditions given by central government, on such conditions as central government deems fit, if it is proved to the satisfaction that a person or an association of person proposed to be registered, not yet registered, proposed to be registered under this act as a limited company has its object the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object, intends to apply its profit or other income in promoting the objects, and intends to prohibit payment of any dividend to its members. Means, अगर कोई company is going to be proposed as a proposed to be registered as a limited company, and object is charitable, religious, and intention that any profit which is earned by this act will be used for the objects, for the society, for the welfare society, and no part of the profit is taken as a dividend, is not to be distributed to the members, then the central government may provide this person or association of person a license to work as charitable, to get a work as charitable company. यानी पहले लाइसेंस मिलेगा, आपको प्रूव करना है सेंट्रल गवर्नमेंट को, भैया हमारा पर्पस क्या है कि हमें समाज के सुधार के लिए काम करना है. जो प्रॉफिट कमाएंगे वो उसे वापस फर्म में रखेंगे, एंड देन दिस प्रॉफिट अर्न विल बी यूज फॉर द बेनिफिट of for the benefit of society, for the object which are given, and no part of the profit will be distributed to the members. Right? So once again I am reading, the central government, that is ROC in this behalf, may grant such a license on such conditions as central government deems fit, if it is proved that to the satisfaction that a person or an association of person proposed to be registered under this act as limited company has in its object the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other object, intends to apply its profit if any or other income in promoting its object, यानी कि अब जो आएगा उसे इन्वेस्ट करना है वापस इसी फर्म में, and intends to prohibit payment of any dividend to its members. Registration of company using license. First is registration. After granting license, an application shall be made to registrar, that is ROC, under sections 8 subsection 1 for registration, and for this purpose application to be filed in form Spice Plus INC 32 with the prescribed fees. Prescribed fees means fees prescribed as per the rules. Documents which should be part of the application: MOA and AOA in INC 13 and the 31 respectively, an estimate of future annual income and expenditure for next 3 years. Please underline नेक्स्ट 3 years, अगले 3 सालों में कहां से पैसा आएगा और कहां उसको यूज करेंगे, फ्रॉम विच सोर्स यू विल गेट द इनकम एंड फॉर विच ऑब्जेक्ट्स यू विल मेक द एक्सपेंडिचर. You have to give the information to the ROC. Then an estimate of the future annual income and expenditure of the company for next 3 years is specifying the source of income and object of the expenditure. This is additional feature which was not in normal company. Declaration, same thing by an advocate, CA, CMA, any cost accountant, company secretary in practice in form number INC 14 by each of the person making the application and by each person making the application in form number INC 15, that what declaration, that MOA and AOA have been drawn up in conformity with the provisions of section 8 and the rules made thereunder, and all the requirements of act and rules relating to the registration of company under section 8 and matter incidental supplemental thereto have been completed. तो क्या क्या सबमिट करना है, what to be submitted, MOA and AOA, estimate of 3 years income and expenditure and their resources and objects, declaration by professional and each one professional plus each one making the application, that all the requirements have been complied. MOA and AOA has been prepared as per the provisions for required for section 8, and all the requirement and act and rules relating to registration of company under section 8 have been complied. Right? Declaration in each type of company is necessary. Alteration of MOA and AOA. It means if company is registered, whether the MOA and AOA can be altered thereafter. The answer is yes, but some requirement. A company registered under this section requires prior permission from central government. And for the alteration of MOA, the power of central government is delegated to regional director. And in case of alteration of AOA, the power is delegated to ROC. So with the permission of central government. Now, conversion of the company into any other kind. Conversion of section 8 company in any other kind of company. What are the terms and conditions? Important. Okay. A special resolution is required to be passed in the general meeting. Second important. Explanatory statement of notice of such general meeting explaining reason for such conversion. यानी कि जो आप नोट एक्सप्लेनेटरी स्टेटमेंट लगाएंगे नोटिस के साथ, मीटिंग कॉल करेंगे आप, जनरल मीटिंग कॉल करनी है फॉर द पासिंग ऑफ स्पेशल रेजोल्यूशन. In the notice of the general meeting to be called for passing special resolution, an explanatory statement should be attached in which the reason for conversion of this charitable company into other kind of company should be clearly mentioned. Application in form number INC 18 should be submitted to regional director with the prescribed fees along with the certified true copy of a special resolution and notice of meeting with explanatory statement. Right? तो एप्लीकेशन जाएगी रीजनल डायरेक्टर को जिसमें जो रेजोल्यूशन पास हुआ एसआर फर्स्ट पॉइंट पे लिखा है एसआर दैट शुड बी एडेड ट्रू कॉपी सर्टिफाइड कॉपी and notice of meeting which showing that there is explanatory statement with the notice which is clearly mentioning the reason for such conversion. Attachment of proof. This is again important point for such section 8 company. Attachment of proof of service of notice. Then notice should also be served to the following authorities, and there should be a proof that you have served the notice to the following authorities by registered post or by hand delivery. यानी अगर बाई पोस्ट भेज रहे हैं तो दैट शुड बी रजिस्टर्ड पोस्ट, या फिर बाय किसी मैसेंजर के जरिए भेज रहे हैं, हैंड डिलीवरी कर रहे हैं, तो दैट शुड बी अ रिसीप्ट कि दैट यू हैव सर्व द डॉक्यूमेंट. किन किन को भेजना है, टू whom, to which authorities this notice should be served. First is CCIT, Chief Commissioner of Income Tax, having jurisdiction over the company. ITO, Income Tax Officer, who has jurisdiction over the company. Charity Commissioner, Chief Secretary of the state in which registered office of the company is situated. Any organization or department of the central government or state government or other authority under whose jurisdiction the company has been operated. तो ये अथॉरिटी जो जो एप्लीकेबल हो रही हो उस एरिया के हिसाब से उनको ये आपको इंफॉर्मेशन भेजनी है. तो ऑल द अथॉरिटीज विच आर देयर एज पर द area of the registered office of the charitable company. So to these authorities you have to send the information. Now any of the above authority may make any representation to RD within 60 days of receipt of notice after giving an opportunity to the company. आपने नोटिस भेज दिया, you have sent the notice to these authorities, and these authorities want to represent before the regional director for any reason, maybe for that this company should not be converted, and they have the authority, have the reason, so they want to present themselves before the director. They have the right, they can be present within 60 days, but for this purpose they should have given a reasonable opportunity of the company for being present. यानी वो जब आप प्रेजेंट करना चाहते हैं रीजनल डायरेक्टर के सामने, तो उससे पहले उन्हें कंपनी को एक मौका देना पड़ेगा अपनी बात को कहने का. ये कह सकते हैं कि भैया हम मना करने जा रहे हैं, तो कंपनी से एक प्रेजेंटेशन आएगा कि क्यों मना करने, क्यों जो अथॉरिटी है वो सेटिस्फाइड नहीं है, वो एग्री नहीं है, तो उनको जो उनके पास रीजन है उनको सेटिस्फाई कर. राइट. नेक्स्ट, a copy of application be filed with RD also be filed to ROC. तो कॉपी RD को रीजनल डायरेक्टर हो गई है, वो ROC को भी भेजी जाएगी. Publishing the notice within a week from submitting the application to RD, at least once in vernacular newspaper and at least once in English newspaper. कम से कम एक लोकल न्यूज़पेपर एंड कम से कम एक इंग्लिश न्यूज़पेपर. And on the website of the company if any, and other website as may be notified or directed by the central. All the financial statement, annual return, other required returns up to financial year preceding the submission of application of RD to be properly submitted. यानी जिस दिन आप RD रीजनल डायरेक्टर को एप्लीकेशन दे रहे हैं फॉर कन्वर्जन, उससे पहले the day financial year ending before the date on which you are presenting the application to RD, so all the financial statement returns, other returns should be properly submitted. Important note: if application is made after the expiry of 3 months from the date of preceding financial year, if application is made after expiry of 3 months from the date of preceding financial year, it means if the application is made on today is 4th October, that is more than after 6 months from the end of the preceding financial year. So a statement of financial position duly certified by CA made up to the date not preceding 30 days of filing the application shall be attached. Means if application is going to be made today, that is 4th October, and previous financial year ends on 31st March 2024, that is more, the time is more than 3 months. Now a financial statement should be prepared and certified by CA up to the date एट लीस्ट 30 डेज बैक जाओ तो 4 अक्टूबर से अप टू 4 सितंबर 2024 एटलीस्ट. उसके बाद का हो सकता है, इट मे बी आफ्टर दैट, it may be up to 10 September, any date after 4th September, but at least up to 4th September should be submitted with the application. Again listen once, again listen this point. If application is submitted after 3 months of the date of previous financial year, then a financial statement should be prepared by company and certified by CA. That should be maximum 30 days preceding. It means, for if we are making the application today, that is 4th October, a financial statement should be attached with the application that should be made up to 4th September. Yani financial statement for the period 1st April to 4th September 2024 should also be clear. On being satisfied, regional director shall issue an order approving the conversion subject to such terms and conditions as it thinks. और लगता है जो जो रिक्वायरमेंट होनी चाहिए वो अपनी कंडीशन लगा सकता है. Before imposing the condition or rejecting the application, अगर कुछ कंडीशन लगा रहा है आरडी या रिजेक्ट कर रहा है एप्लीकेशन, the company shall be given a reasonable opportunity of being heard of to present itself. After approval of RD, if approval is given by the regional director, a special resolution shall be passed for amendment in MOA and AOA, and that should be filed with ROC with declaration to other condition imposed by regional director. यानी कि if approval is given by regional director, so SR should also be passed for amendment in MOA, and declaration will be made by the company to the ROC that all the conditions, if any, made by regional director regarding the conversion have been complied with. अगर regional director condition लगाई है तो वो हमने सारी की सारी पूरी कर ली है. And on the receipt of document referred over, the registrar, that is ROC, shall register the document and issue the fresh certificate of incorporation. Right? Please read the point number 7, 8, 9, 10 once again for one. I am giving the 1 minute. Then I will come to the next slide. Queries आपकी लेंगे इन खत्म होने के बाद, ये टॉपिक खत्म होने के बाद, before starting the third super over. So please wait and please हम्बल रिक्वेस्ट, मेरा हाथ जोड़ के निवेदन है मेरे बच्चों से कि जरा प्लीज म्यूट कर लीजिए, बच्चों डिस्टर्ब हो जाता है. ठीक है. The revocation of license of charitable company. If central government, power delegated to regional director, the central government may by order revoke the license where in these conditions, in these situations, company contravenes any of the condition subject to which a license is issued. कंडीशन लगाई थी वो आपने पूरी नहीं की, और अफेयर्स ऑफ द कंपनी आर कंडक्टेड fraudulently in violation of the object of the company. It means you are not going for as a non-profit making, you are going as a profit making company, or any object which is prejudicial to the public के खिलाफ कुछ कर रहे हैं. In that case, central government, that is the RCM director, has power to revoke the license. On important note, on revocation, ROC shall put the limited or private limited against the name in the register. जब लाइसेंस रिवोक हो गया तो आपकी कंपनी के नाम के आगे लिमिटेड या प्राइवेट लिमिटेड लिख जाएगा. Now on revocation, the central government may order either for winding up of the company or amalgamate with another company registered under this section and having similar objects. यानी कि ये कंपनी काम नहीं कर रही है, अच्छा तो इसको अमालगमेट कर दो किसी दूसरी कंपनी से which is working as a charitable company and working as per the objects of the. So in what situation central government may revoke? If company contravenes the conditions subject to which license is given or working fraudulently in violation of object of company or against the public interest. ठीक है? And on revocation, the central government may order for winding up or for amalgamation with the other company having similar objects. Right? So revocation license की process है ये देखिए, listen. Contravention, then license revoke, expression limited or private limited added to the name of the company. It may be winding up of the surplus assets that will be winding up, and surplus assets will be transferred to section 8 company with similar objects or insolvency and bankruptcy fund, or order for amalgamate with section 8 company with similar business. But punishment is also there. In case of company, punishment is 10 lakh to 1 crore, and director or officer who are in default with 25,000 to 25 lakhs, and the fraud, then punishment under section 447 will be there, right? Benefits for section 8 companies. There are some benefits or privileges for section 8 companies. They are inclusive list. They can call its general meeting by giving a clear 14 days notice instead of 21 days notice. General company के लिए होता है 21 दिन clear days notice, but in this case the company registered under the section 8, the meeting can be called by giving a clear 14 days notice. Requirement of minimum number of directors, independent directors does not apply to these companies. Need not constitute nomination and remuneration committee and shareholder relationship committee for this type of company. These were the privileges available to scheduled company. Now, the concept of effect of registration. This will be the last slide before super over 3 for today's part. Subscriber to the memorandum. Subscriber to the memorandum and all other person who may from time to time become member of the company. Registration हो गया, तो जो सब्सक्राइबर है वो मेंबर बन गए, एंड जो उसके बाद all other person from time to time become the member. Company got registered from the date which is printed on the certificate of incorporation, and from the date of incorporation specified in the certificate of incorporation become body corporate by the name specified in the memorandum and in fact in the certificate of incorporation. And under said name, company can exercise all the function of an incorporated company. It has a power to acquire, hold any disposable, hold or dispose of property, whether movable, immovable, tangible or intangible. The company can contract and sue and be sued, and company will have the perpetual success. Right? So this was the from myself today's session before third over, and this is third super over. This is the last super over. If there are any query, so you can ask, then we will come to the super over 3. अभी तक मेरे पास कोई क्वेरी नहीं है. आई थिंक कंसेप्ट इज क्लियर. तो लेट्स गो फॉर सुपर ओवर 3. ठीक है. फर्स्ट क्वेश्चन, which of the one person, someone is asking, sir, can you give the example of one person company? I think एग्जाम्पल से क्या मतलब है बेटे, आप एक बार जाइए साइट पर, डाउनलोड कर लीजिए, नाम मिल जाएगा कंपनी का आपको. बहुत कंपनियां होंगी 1% कंपनी के नाम से, ठीक है। Which of the following is a requirement for a company to be incorporated under Section 8? It must have a minimum paid up capital of 1 lakh. It must have a profit making motive. Its activities should benefit the public or specific community. It must be limited to 2 directors. Someone is asking, sir, CCIT, Chief Commissioner of Income Tax. Next question. Which of the following is true regarding the profits of Section 8 company? Profit can be distributed to members as dividend. Profit must be reinvested in the company's activities. Profit can be distributed to directors as bonuses. There are no restrictions on profit distribution. Third question. What additional step is required when applying for the incorporation of company of Section 8 company compared to other company? Obtaining a license from central government, filing a tax return, appointing a company secretary, publishing a public notice. What is the status of Section 8 company in terms of liability? It has unlimited liability. It has limited liability. It has limited liability only for directors. It has no liability. Which of the following activities is not permitted for a Section 8 company? Conducting charitable activities, engaging in commercial activities for profit, promoting educational initiatives, undertaking social welfare projects. What happens if a Section 8 company fails to comply with the conditions specified in its license? It may be dissolved automatically. The central government may revoke its license. It will incur additional taxes. Its director will be personally liable for debts. So let's start the answers. First is, Which of the following is a requirement for a company to be incorporated under Section 8? Its activities should benefit the public or a specific community. Which of the following is true about the profits of Section 8 company? Profit must be reinvested in the company's activities. What additional step is required? A license from central government. What is the status of Section 8 company in terms of liability? It has limited liability. Which of the following activities is not permitted? Engaging in commercial activities for profit. What happens if Section 8 company fails to comply the conditions specified in the license? Central government may revoke the license. So this was super over 3 for today's session. Let's check किन किन ने सही आंसर दिए हैं. चलिए मैं नाम ले रहा हूं, उससे पहले मेरी एक बात सुन लीजिए बच्चों, प्लीज लिसन, बिकॉज अगर मैंने नाम ली तो आप लोग चले जाओगे, मेरी बात नहीं सुन पाओगे. Please listen my words. What we have discussed today, just give next 15 minutes to get revision what we have discussed. This will be permanently saved in your mind. एक बार अगर रिवीजन कर लोगे ना 15 मिनट क्लास खत्म होने के बाद, जो हमने पढ़ा है बिल्कुल सेव हो जाएगा दिमाग में. वो एक डायलॉग था ना शोले फिल्म का, संजीव कुमार जी का, लोहा गरम है मार दो हथौड़ा. पिछले 2-2.25 घंटे से हम दिमाग का लोहा गर्म करे जा रहे हैं, गर्म हो गया है बहुत तेज. बस इस पर हथौड़ा मारना है, एक बार उसे दोबारा रिवाइज करना है, और दैट विल बी परमानेंटली सेव इन योर माइंड, राइट? सो लेट्स स्टार्ट. फर्स्ट वन इज मिस्टर ओम कृष्ण ओम गुप्ता, कॉन्ग्रेचुलेशन. स्वाति, अभिषेक, कॉन्ग्रेचुलेशन. ऋषभ, congratulations. Ayushi, congratulations. Kiran, congratulations. Khushi, congratulations. Ritu, Sai, Kiran, congratulations both of you. Abhijit, congratulations बच्चे. Arin, congratulations. तो मैं सभी को बधाई मेरी तरफ से, बट प्लीज रिमेंबर माय वर्ड्स कि इसको एक बार रिवीजन कर लो अभी. प्लीज गेट रिवाइज. जस्ट गिव द 15 मिनट्स आफ्टर दिस क्लास, राइट? एंड डेफिनेटली दिस विल बी permanently saved in your mind, right? So now we are ending the session for today. In the next session we will complete this chapter, and in that session we will discuss MOA, AOA, contents of MOA, AOA, way of alteration in MOA and AOA. Hopefully you enjoyed your studies. क्लास में मजा आया होगा, उसके लिए मेरी तरफ से आप लोगों को बहुत बधाइयां. सबने आंसर सही दिए, मैक्सिमम लोगों ने आंसर सही दिए. Very good. And my blessings are always with you. And we will meet in the next class on Sunday, the same time. सर चैप्टर 2 का वेटेज क्या होगा अप्रोक्सीमेट? देखिए मेरे हिसाब से इंपॉर्टेंट टॉपिक्स जो हैं वो है चैरिटेबल कंपनी, ओपीसी, alteration in the MOA. So these were the one question, at least one question may be asked from this chapter, right? Bhargav ji, can you hear me? ठीक है, so अभी क्लास ऑफ कर रहे हैं, एक क्वेरी और ले रहा हूँ बच्चे की, फिर अपन क्लास आज की क्लोज कर रहे हैं सर, ठीक है? एक क्वेरी है मिस्टर अभिजीत चौधरी जी, सर विच टाइप ऑफ क्वेश्चन एक्सपेक्ट? देखिए इन माय व्यूज देयर शुड बी अ डिस्क्रिप्टिव क्वेश्चन in this chapter, maybe from OPC, maybe from charitable company, and maybe from alteration of MOA. So I think if you have the idea of the chapter, the question may be in any form, you will be eligible for to answer, right? So thank you so much everyone. Thank you so much. Thank you for patient hearing. Thank you everyone. Sir, class is now end. ठीक है? Thank you. All the best.
Thank you, sir.
Thank you. Thank you. Thank you.
Thank you, sir.